Let's look at the first way we can not have consent in a contract, and that happens if there's been a mistake. Now, look, generally, the law is not going to care if you've made a mistake when you're contracting. That's that rule of caveat emptor, or buyer beware. So it will really only say that mistake leads to a lack of consent in some very specific circumstances. There are three kinds of mistakes that we can be interested in: a unilateral mistake, a common mistake, or a mutual mistake. So let's have a look at those three and some cases to try and help us understand it a little bit better. Let's look at the first way that we may lack consent, and that's with mistake. Now, the most important thing to remember here is that generally the law won't say that there's a lack of consent if you've made a mistake. Most of the time it wants to uphold the ability to contract. And so it's only under some very specific circumstances that we'll find mistake leads to a lack of consent. Saying it's not just any mistake. This must be a fundamental mistake about something that's very important to the contract. And what it does is it makes the contract unenforceable. It makes it ineffective and unenforceable. And legally, the term we would use is void. The contract is void. So here are the three kinds of mistake that we need to be aware of. The first is a unilateral mistake. Now that occurs where only one party makes the mistake, unilateral mistake, but there's a second condition that needs to be satisfied, and that is that the other party must have known or suspected it and taken advantage of it. So it really has that air of one of the parties not doing the right thing for a unilateral mistake to lead to a contract that's void. The second kind is a common mistake, and in the common mistake we have both parties making a mistake about a fundamental aspect of the contract. So they're both mistaken about something that's very important to the contract. The third kind of mistake that we can see here, is the mutual mistake. Now the mutual mistake is where people believe they've got a meeting of minds, but they actually haven't. They're mistaken that they've got a contract. So it's not a mistake about a fundamental issue of the contract. It's an actual mistake as to whether they've agreed as to what the contract actually is. So the unilateral mistake occurs where one party makes a mistake and the other party knows or should have known about that mistake. Most of these unilateral mistake cases involve a mistake about the identity of the person, and that's a fundamental element of the contract when you think about it, who you're actually contracting with. So it's hard to make out a unilateral mistake. It must be fundamental, and the other party must know or should have known about the mistake and take advantage of it. Unilateral mistake around identity can be made out with the rules set down in Cundy and Lindsey. You can see here that there are three aspects to the rule. One of the parties must be mistaken as to the identity of the other party. The identity of the other party is actually fundamental to the contract, so it must be important that it was the other party. And the other party must know about that mistake and seek to rely on it. So they've taken advantage of the mistake made by the other person. The general rule is if people have met face to face, that you can't make this out. You actually knew who you were contracting with. So most of these cases are going to involve people actually not meeting face to face if you're going to be able to make out unilateral mistake based upon the identity of the person that you're actually contracting with. Let's look at the case of Cundy and Bevington and Lindsey. What we have is a bit of a swindler by the name of Blencarn. So let's get the pen right. So we've got Blencarn, who's our swindler, in red, and we've got Lindsey over here in green. And Blencarn, the swindle he's going to do is he sends a letter ordering some goods to Lindsey. He orders the goods and he actually signs his name so that it looks like not Blencarn, but it looks like Blenkiron and Company. Now, it actually happens that Blenkiron is a firm with a great reputation. So what does Lindsey do as a result of this? Well, he sees this order for goods coming from what he thinks is this reputable firm, Blenkiron, when it's actually Blencarn, and so he sends the goods on credit. So these goods go over here on credit. So that means that Blencarn hasn't paid for the goods. So Blencarn gets these goods, and what does he do? He sells them to someone else. He sells them to an innocent party down here by the name of Cundy. And then, of course, Blencarn shoots off with all of the money. So he's disappeared out of the picture. He's got all the money. Cundy now has the goods, and Lindsey needs to either get the goods back or get some money. Now, there's a rule in law that I'm not going to bother explaining to you in great detail, but it actually says you can only sell goods legally when you have good title to them. So what that means is that if Blencarn is not deemed to have had a contract with Lindsey, it will mean he doesn't own the goods. And if he doesn't own the goods, it means he can't pass title or ownership to Cundy. If that's the case, then Lindsey can get those goods back. If instead there is a contract here, then Blencarn does own the goods and can sell them to Cundy, and Cundy can keep the goods, and Lindsey has to get the money off Blencarn. So this action is actually all about Lindsey trying to get the goods back off Cundy. And what did the court say? The court said that in this instance, the contract between Lindsey and Blencarn, so this contract here, was actually void for unilateral mistake. Now, notice it's a unilateral mistake because it's only one party making the mistake. Notice also it's about the identity of the person, the identity whether it's Blencarn or Blenkiron, and note that Blencarn has taken advantage of that. So because of that, the courts decided in this instance that it was a void contract. That meant that Blencarn didn't have title to pass to Cundy, and the goods should actually go back to Lindsey. And it's up to Cundy to get the money back off Blencarn. So as you can see, a little bit of a complicated case, but the important part for us to see is that there was a unilateral mistake about the identity of the other party that was known to the other party because they were a shyster, and that they took advantage of that. If we have those circumstances, we can make out unilateral mistake and say that there is a void or no contract in place. Now, remember what we said before, that it will be unlikely that if the parties have met that you can make out this unilateral mistake. So let's look at a case that looks very similar, but the outcome is different. Pappas and Bianca Investments. So again, we've got a swindler involved. Let's call them S. S for swindler. We'll make them red. And we've got a swindler here, and they're dealing with our car seller, Pappas. So Pappas actually sells a car to a buyer who's a swindler, and the swindler has false identification. But of course, the swindler hasn't given any money to Pappas at this time. This swindler then goes to a third party, and the third party, from the name of the case we can see, is Bianca Investments, and they're a pawnbroker, and so he gives the car, so the car has gone, so we've got the car here, and then he gives the car to the pawnbroker, and the pawnbroker gives back to the swindler some money, and you can guess it, the swindler's out of there with the money. So now Pappas doesn't have any money, Bianca Investments has the car, the swindler's gone, and the question is, we can see the car, no one's ever going to get any money from the swindler. who has ownership of the car. You'll remember in our previous case of Cundy and Lindsey that in that instance there was no title because there was unilateral mistake, that the person who sent the goods could make out the case that they didn't send it to who they thought they did. So Pappas tries to make this case out here and says, well, you know, they had false ID, this was a swindler, I actually didn't know who I was contracting with. So because of that, there should be a unilateral mistake because I didn't know who I was contracting with. That's a major part of the contract. That party took advantage of it. And what did the court say? The court said, no. What they said was, look, the person might have been using false identification, but you actually knew because you dealt face to face, you knew who you were dealing with. So because of that, there was no unilateral mistake. It was the person who you thought it was. It's just that they lied to you. So because of that, there was a contract. So here there is a contract. And Bianca Investments, they get to keep the car. And Pappas has to try and find the swindler to get the money back off them. So quite a different situation. You can see here though that the court said because they had met in person, you did know who you were dealing with. It's just that they lied to you. That was different to the case of Cundy and Bevington, where you actually didn't know who you were dealing with because it all happened via letter. Here's a third case, Lewis and Avery. Very similar circumstances that I'll leave you to read on your own and think about. It was really the same finding that when the two people have met in place, with us, and even if one of them's a swindler lying to them, you actually know who you're dealing with, right? So it's not the unilateral mistake in the sense that it is if there's correspondence involved and you don't genuinely know who you're dealing with. Very occasionally, you can make out unilateral mistake around the kind of contract that you've dealt with. This will happen very, very rarely though, because the courts they make the presumption that if you've signed a contract, etc., that you knew what was in it, and caveat emptor applies. This exception is, let's use the Latin phrase, non est factum. So most times the courts are very unsympathetic if you haven't read the contract. But under some very limited circumstances, they will hold a unilateral mistake. And it's important to understand how limited that context actually is. Your sense of it, non est factum means not my deed or not my action. So it's really saying that while I signed it, it really wasn't what I meant to do in any way, shape or form. And to make that out, it really means the conditions have to be that you have no idea what you're doing. So what are these kind of conditions where this will apply? You can see on this slide that the requirements of non est factum require someone who really can't read the contract because they're blind, illiterate, can't read English, or that they were induced not to read it as the result of the actions of the other party, a misleading representation. So you can see that either the other party mustn't be coming with clean hands, they've done something wrong around the action, or the other party just physically can't read it. And two, they must be mistaken about the fundamental nature of the document that they're signing. So they have to be signing something that they had no idea what they were signing. If you can make those two out, you've established non est factum, that it is not what you intended to actually do. Again, a nice case to think about this, Peddlin and Cullen. P spoke little English, couldn't read English at all. He granted an option to Cullen, granting Cullen the right to purchase land belonging to him within a certain period. That period expires, C wants an extension. He sent P $50 and asked him to sign a document that he described as a receipt for the $50. P signs the receipt without reading it. The document, in fact, granted an extension of the option. So when he attempts to exercise the option, Peddlin says, I don't want to sell you the land, I didn't know what I was signing. In this case, Peddlin could rely on non est factum and wasn't obliged to comply with the option. Why? Look at the conditions there. Couldn't actually read it because he couldn't read English. Cullen induced him to sign the document and said it was something, there was a representation about what that document, he said it was a receipt when it wasn't. So we have those two conditions being met. So two conditions for the first part of non-est factum. The second thing that we see occurring is that Peatland was fundamentally misunderstanding about what the nature of the document was that he was signing. He thought it was a receipt when it was actually an option. So we have those two conditions, not being able to read and write, being induced by the other party, to not knowing what they were actually signing.